487-835, Sean Colt and Alyssa Plummer. Counsel, your appearances and bar numbers.
Good morning, Your Honor. Briggs Department 9043, appearing on bundle on behalf of the plaintiff, who's also present.
Unbundled, so noted. Okay.
Kelly Stout, bar number 12105, on behalf of Alyssa Plummer. Also with me today is Amanda Stevens.
13966.
Are you both with the same firm?
Yes. Bailey Kennedy.
Okay. Just a procedural matter. I see a court date of December 7th on plaintiff's motion to reconsider to vacate the default judgment. Is everybody aware of that? December 7th date?
Your Honor, if I may,
Yes.
I just became aware of it when I checked the docket in preparation for this hearing. I was never served with a motion. Ms. Plummer never received a copy of the motion.
And Dad filed it pro per? Yeah.
Yes, I just...
And what's on for today? A motion to rehear. It's the same exact motion, isn't it? Is it the same motion?
We filed two separate documents. We filed a final order, and then we also filed a default, though the order today also could
He
change.
missed calendar call on September 2nd. There's the default on September 23rd. And the order has not been filed. You just have the default, so it's probably sitting upstairs. But at any rate,
we have an order and a default that have been entered.
Default, I see. I don't know if the actual custody order, permanent order is in place.
I don't see that.
Nothing yet. Nothing's been logged in.
It was...
I haven't seen it.
Notwithstanding, we still have to hear this motion to rehear and argue it. I'm going to assume that his pro per motion to reconsider is the same exact thing he's asking for in the motion to rehear that's on before me today. So I'd like to vacate December 7th. Unless you want a continuance, you want an opportunity to oppose, but you already did an opposition, we would just leave everything to oral argument.
I believe that your decision on the motion that's on for today
It's just-
encompasses the motion.
It seems duplicative. Have you seen the motion to reconsider that Dad filed?
Actually, I looked at the motion just for today's hearing.
And opposing counsel says they haven't even been served with the motion to reconsider.
But it seems like if, depending on your
I
decision...
looked at it, it's the same thing. Maybe he might have added a few things. Is it the same exact thing you wrote?
Then let's just hear it all today.
Your motion?
He's asking for the same relief.
Yeah, it's procedural. We got a rule on that. Okay. Mr. Grigsby, you up to speed?
Yes, Your Honor.
I do have a note here. Dad has different mailing addresses, and he failed to update his address, possibly. I have him on Dusty Creek, 945.
No, I can update
See,
that.
that's why. You have to file notices of change of address, sir. So we got to get that squared away. What's your address for the record where you get your mail?
3651 North Rancho
Unit.
Drive. North Rancho Drive.
Right,
apartment
unit number?
124.
Okay, is that in your last motion to rehear? And the zip code is...
9130.
Okay, give him a change of address form, we'll get that done. In the future, he will receive his mail, and I guess he lives there at North Rancho. And when we get the notice to change of address, we'll update that in the computer. Okay? Yes, Mr. Grigsby, you want to argue for him why he missed the counter call date?
Yes, Your Honor. This appears to be, really, when I look at it, it just appears to be a 60B motion. And speaking to my client, he kind of articulates in his motion that he got a little confused regarding all the dates. I believe they just had a court date a couple weeks before the September 2nd date.
Yeah, Discovery Commissioner on August 21st.
Yes. And he's representing himself in proper person, and I think by his actions, easily constitutes what's been normally found to be excusable neglect or mistake of, or legal mistake. He mistook the court date. I wouldn't take it as an evidence of intent on his to abandon the case. He's been participating in this case for over a year.
Okay.
Additionally, I believe there was, at least when I reviewed it, I believe there was a senior judge sitting that day for the calendar call. And who was the one?
Judge Bixler?
Yes. Senior judge who, lack of better words, has a reputation for lack of patience.
Okay.
And
Now, my JEA, also on March 24th, sometime in March, mailed it to North Grand Canyon, Unit 1038. Is that another old address?
Yeah, that was...
8250 North Grand Canyon, Unit 1038, 89166.
Yeah, that was
That was back in March. You moved like once, twice? Because that's when we set the date for the counter call. Let me see, that did not move, right? Let me see what we put. We had it for September 2nd at 9:30. That was the last order-setting hearing back in March.
That's it. I mean,
No.
he just mistook the dates. I mean,
He's got to keep updating his addresses, or he's not going to get this stuff in the mail.
He understands that, and if this is set aside, I guess his intent is to retain counsel because he now sees the problems he can get into representing himself in these type of matters.
Okay, he was in court on, do you remember you were in court February 25th? I verbally announced this is our court date, calendar call, set on September 2nd at 9:30. You didn't write that down, and then my secretary tried to mail it right after that, but mailed it at your Grand Canyon address, because that's what you gave us at the time. And if from February until now, till September, you missed the court date, you got totally confused about court dates.
When the August 21st, I thought that because they had moved up the court hearing, that's what I thought, and they were trying to move up the discovery.
And you thought that was the calendar call?
Yes, ma'am.
Anything else, Mr. Grigsby?
I just also want to point out about going through.
Is it going
You
right?
know about the policies about Supreme Court's policies, deciding matters and the merits and how it's heightened in custody cases. And I'd suggest, given the fact that he's participated in the case up to that point and missed the calendar call date, and that the penalty was fairly severe in the custody, him being defaulted, I'd ask the court to set it aside, allows the matter to allow him to proceed on the merits.
All right, Ms. Stout, when did your firm get hired? Or you've been on the case?
Yes.
You've been
Yes,
on the
Your Honor.
case. Okay.
I
I
would
think there's
just-
no question. I announced the court date in February 25th at a court hearing.
You
My
did.
secretary followed it up and mailed you a copy of the order-setting evidentiary hearing.
Yes, Your
And you
Honor.
appeared on the September 2nd date.
September 2nd calendar call was originally set September 22nd, 2014. The court minutes reflect that.
Correct. Never was changed. And you appeared.
The calendar call was not changed. I believe the date of the evidentiary hearing changed in the second amended order.
So as a matter of law, is it excusable neglect to miss a court date, thinking he got confused by appearing at the Discovery Commissioner's hearing?
Additionally, Your Honor, at the Discovery Commissioner hearing, there was discussion of calendar call, and that was the basis of the need for having the motion heard on shortened time and the very short amount of time that the Discovery Commissioner gave Mr. Colt to respond to Discovery.
Commissioner Baycroft announced that they had a court date coming up on September 2nd.
I don't know if I do not remember him stating the date, but we did talk about the upcoming calendar call, and that was the need for him to produce Discovery by the previous Friday.
Okay.
Additionally, I corresponded with him via email, and I left him voicemail messages. My declaration in support of our pretrial memorandum sets forth those details and attaches the emails and authenticates them.
Okay.
Mr. Colt did not communicate with me regarding his Discovery responses. He did not communicate with me regarding my request for a pretrial conference. He did not produce a list of witnesses. He has never produced any documents in this case. I would dispute that he has been a full participant in this matter.
Okay. So that's that. He missed the court date and he knew about it, and it's not your problem that he got confused about court dates. Okay. Anything in rebuttal, Mr. Grigsby?
Yes, Your Honor. I've made that very same argument tons of times, even against attorneys who miss calendar dates. And, I believe with the number of dates that moved in this case, for someone who's representing themselves to get a bit confused by all the dates would constitute excusable neglect or mistake of fact, that the mistake of fact being that the hearing they had earlier in August was in fact the hearing. Just from my view of the record, it actually had to sit down because lots of dates appear to have moved in this case. When I was reviewing Odyssey after being retained for this hearing, I just say under those facts, it's reasonable that he may have come to a mistake. I understand that's the danger you take when you embark upon representing yourself, but in his 60B motion, which I think that's what actually his motion to rehearing actually is, he did cite NRCP 60B, and there, I think he meets the standard on it. We'd ask the court to set it aside, reset the trial date, and allow him to.
Is this your first time appearing in this case?
Yes.
Okay. Do you know if your client, in speaking with him, has ever missed a court date in this case?
Not that I'm aware of.
His mom? His mom ever missed a court? I mean, not mom. Has dad ever missed a court date? We've had how many hearings? A dozen? 1, 2, couple continuances. We've been trying to get to trial. 3, 4, 5, 6, 7. Just looking at this, 8, 9, 10. Have you ever missed a court date? Is that the first time it happened?
No, ma'am, I haven't missed the court date.
You haven't missed a court date? All right. Based on what I've heard this morning, just arguing procedurally on the 60B set aside, the court finds excusable neglect. He's never missed a court date. We've had a dozen court dates. And I would admonish him not to get confused about court dates in the future. You do appear in court. You did appear at the Discovery Commissioner. You still have to answer to the Discovery Commissioner's orders there, and then we have to deal with that. It might impact what Commissioner Beecroft said here. Those minutes are done. There was some exhibits I saw, so I'm going to set aside the order from the September 2nd calendar column. We move this thing to trial again. We've been trying to get to trial. Now, he had might have been discussed in your, you have a counter motion, Ms. Stout? Might have been discussed there.
I'm sorry?
You just filed an opposition. So what we're going to have is the kind of a verbal discussion day, what the impact is. If he is, because I'm going to set it for trial, but he's still stuck with any discovery orders unless he did a 10-day objection. You weren't there at the Discovery Commissioners. You know, he had like a week or something to get his responses in.
I emailed her the responses.
Huh?
I would like to address that order because I believe that order also would hold him in default.
He had until Friday, the 28th of August, to send you his discovery. There is an email he did attach as an exhibit with an attachment, I suppose, or his responses.
He attached partial responses to some of our interrogatories. He did not produce any responses to our request for admission or our request for production of documents.
And the Commissioner Beecroft said if you fails to respond, he would strike the complaint and enter a default.
Yes, Your Honor.
You got to get caught up on that. You know what's going on with discovery?
No, actually,
since
I was kind of retained for the 60B motion.
Right.
So I actually didn't
You
look
wouldn't
at
know the
discovery
impact
stuff.
on it.
I wasn't.
Is he going to hire you again to
That's-
clean this mess up?
I think that's his intention was
But
to
see,
hire
the
me.
other side's going to, they're saying now he had the opportunity. He did sort of, I guess he's going to argue he made a good faith effort to give what they claim partial responses.
He did not
but it
finally
was-
serve the responses.
And that
Your
was
Honor.
only to interrogatories. He didn't respond to requests for admissions and didn't respond to,
As I said, I'm not prepared to argue that one way or the other. I mean, if he does retain me, which I believe was his intention, if this was set aside.
has the
then-
Discovery Commissioner's recommendations been reduced to an order?
Yes, they were, Your Honor.
Oh, boy. Then he missed his 5-10 day to appeal it, object?
And you signed an order adopting those Discovery Commissioners' recommendation. The notice of entry was entered on September 18th, 2015.
I may have to appeal the Discovery Commissioner. It's way beyond that filing, time filing. You know what that means? I may not necessarily strike his complaint, but he'll only be the only one allowed to testify. He can't bring witnesses and he can't bring exhibits. And if he hires you to do the trial, it will just be him. Won't be allowed to bring witnesses or exhibits. But he would get his day in court and get his trial, but it's up to him to comply with discovery.
And like I said, I'll look at that and see. Except I'm not prepared to even argue whether he complied, how much he complied, because I wasn't retained kind of unbundled to do one thing.
Right. When a commissioner issues you've done discovery hearings. When a
Yes, I've
commissioner
done discovery
issues
hearings.
orders, it becomes final orders of the court unless it's appealed.
Unless it's objected to.
Yeah. Well, not knowing the law and being a layperson, I don't think is ignorance of excusable neglect. Each party, both sides are held to the same standards.
And like I said, I'll look at that to see if he was actually served with the recommendations. Because it sounds like, just from what you said this morning, there may be some issues
From
with
what it sounds like,
Yes.
he might be headed to a fact of a finding. Orders were made, finality of the order. You can bring yourself to trial, but you won't bring your own witnesses, or you won't be allowed witnesses or exhibits. You're allowed to cross-examine. He's allowed to give his testimony, but he'd be the only witness on his side.
And like I said, if that's the situation, then I guess we'll deal with that when it comes up.
Set it for trial. Our first available, you're looking at July for a full dayer, or you want 2 half days? They might be a little bit. In the meantime, that means because of this ruling, we revert back to the temporary orders. Unless she had a counter motion, but where is Alyssa at in terms of her contact with the child?
She's been the primary caregiver since the order was entered in September.
I haven't, You mean September 2nd? That order's, the motion to rehear is granted. The order from the counter call, the final decree is set aside. We move this thing to trial. Both parties are going to contest it, but the prior temporary orders haven't, looks like we're September 22nd. I haven't updated, I haven't seen these parties for months, but Dad wants to take a drug test. Check the left side of the file if we got his drug test from 2/25.
He says he did that.
Probably tested clean. I would, if he was dirty, I would have said a 72-hour hearing. Okay, and Mom was still to follow the temporary orders. The parties were to follow the temporary orders. August 11th? He was negative? Yeah, Mom will probably, it's been August, over a year. Mom had, I denied at the time her motion to lift the supervised visits, but have her visits gone like clockwork without any issues? Has she resolved her criminal cases?
It has, Your Honor. The documents were served in discovery showing the resolution. There was no, the final resolution did not include a conviction for domestic battery.
You representing her in the criminal?
I am not, Your Honor.
She had a public defender? And you have, and all her criminal cases are done?
Yes, Your Honor.
Dismissed, went to trial, not guilty, no conviction, what happened?
I believe that there was a plea in each of those cases.
I'm not following, yeah.
Just the one for my brother, I got disorder.
You're going to have probably double check her criminal
Yes.
case. You have to look that up. Sean been following it?
She was in jail for a month or something. I'm not completely sure what happened. I thought
Warrants?
she pled guilty.
Your Honor, all of the convictions.
I'm
have been
talking
resolved.
about, since we last talked about her custody back on
There has been no
August
change.
11th, 2014. Like 14 months ago was the last time I had a discussion about her.
Honestly,
There has been no change since that time, Your Honor.
And because I was only
In terms of her criminal case, or?
Correct. All of the charges had been resolved at that time. No new charges have been filed.
Okay, and she's been taking her visitation like clockwork?
Yes, Your Honor.
He hasn't.
And I gave you both, well, I gave counsel at the time the CPS records. If you need those, we can email those to you under a gag order. You're gonna, if he's gonna hire you for trial. And if she's taken her visitation, like clockwork,
Yes, Your Honor. Since the hearing.
in a year.
Yeah, everything.
She's asking today, I'm assuming, to lift any supervised visits.
Yes, Your
Did
Honor.
she actually, well, she didn't have the order in place, so she's still taking them supervised, right?
She is taking them unsupervised, yes, because we've been operating under the order that was entered after the counter call.
Now, Dad says since August 11th, 2014, Mom landed in jail for a month?
Sorry?
Mom had been in jail this year, last year?
Oh.
This year. He thinks she was in jail
I'm
this
sorry,
year.
Your Honor, I misunderstood. I thought you
Okay.
were talking about August of 2015, which
Yeah.
is, I think, when
No,
we
this
were
was the
last.
hearing, this has been 14 months. Since court, 14 months ago. Have
Last
you
time
landed
that
in
we
jail?
were here, she had resolved all of her cases. I believe it was much more recently, though, than August of 2014.
But Alyssa, did you go to jail for like a month this
I
year?
went to jail for his case, the one where he lied and put me in jail.
The North Las Vegas case?
The one for his case.
Which court?
It was North Las Vegas.
Why did you were arrested?
I
Or you
got
turned yourself in?
arrested I got arrested, but those charges were dropped. But just because I was arrested, I had what do
How were you
call it?
arrested? Were you pulled over or you showed up in court?
I was in court. It was okay.
You were
I
in
got-
court
I
and then they
got,
put you in jail?
They gave me a 90 days squash unless I got in trouble. I got arrested, but the charges were dropped.
Charges
so
were
I
dropped?
served the time for the lie that he told.
Rick still have to look into that.
Have to look into it.
You're
Now,
done? You tell me you're done with all your criminal cases?
I am done.
Yeah, if
All
you
of them
don't
are
leave
resolved.
If you don't leave the date for the 7th on, I can actually come back prepared to know. Because I know nothing about the criminal cases. I prepared for one issue today. If he's going to retain me for that, then I can come back prepared on the 7th to update this court with documents of what's happened in the case. It sounds like she doesn't.
Dad's
sound
not
quite sure.
agreeable to...
I am 100%
She's
sure.
not 100% sure. As somebody who actually practices criminal law, what she's saying doesn't
Okay.
make.
Technically, that's not before me today. You didn't have a counter motion on that. I could leave the 7th on. Dad's not willing to lift a supervised visitation.
I
After
didn't
14
ask him. I
months.
was listening to what you guys were saying. So
It's already lifted.
This is just me updating the case. 14 months, taking her visitation. She would just keep the schedule. Dad retains primary to be unsupervised.
He said he doesn't have a problem with lifting the supervised visitation.
And we'll vacate December 7th. You don't need to come back to court on that. I'm going to lift the supervised restriction. You have unsupervised visitation as long as you're regular and continuing what you're doing and picking up the child consistently.
So,
Is there a need for a change in the schedule?
Yes, sir.
I'd say
Temporarily, Dad retains primary, and I think he has sole legal, doesn't he, right now?
No, joint
It's
legal.
joint legal, primary with Dad, unsupervised now, unrestricted visitation for Mom, and pickups and drop-offs. Any changes in work schedules?
In the Friday morning to Sunday morning works.
How old's
best for me.
Preston? Is he in school?
He's not in school
He's
yet.
still, he's what?
He's 2.5.
2.5? Okay.
Friday morning to Sunday morning works best for me, unless my mom can facilitate the exchange in the
Weekends
evening.
for Mom? That's what Dad's, either the schedule that you've been following supervised becomes unsupervised, or Dad says you can do Friday morning to Sunday morning with you.
Doesn't even pick him up when he's supposed to pick him up.
If Your Honor might be willing to trail this, and counsel and I can speak about it in terms of a schedule.
Okay, you get
Would
5
that be-
minutes. Go ahead. Trail the matter. I'll take a case in between. Hopefully it's just a quick case.
And yeah,
I can take a break
I was
too.
going to say, as soon as I walk out there, as soon as I walk out, Tyler's going to grab me and take me down to Department A.
How about we have a conference room?
I know Tyler.
You gotta go?
Yeah, because I was waiting for him.
He's got to go to another court hearing. I could just leave the default schedule, whatever the last court order was, or Mom tells me right now she wants to change her two and a half days.
To keep the order in place.
She'd like to
Okay.
keep the order
With
that...
no restrictions?
She'd like to keep the schedule that was ordered in the
Dad's
September 2nd
going to make it
order.
happen. She has court-ordered visitation back in whenever I ordered it, 14 months ago, I suppose. No, September, no. September's long gone.
So, yeah,
What was the old order?
I believe it was Friday 6:30 to Sunday 6:30, supervised.
Right, and you want mornings, switch to mornings, you can exchange
Or
in the
that-
daytime.
that's- If we're going back to the temporary, that's fine, because my mom can give her the baby on Friday.
We'll file a motion to modify.
Okay.
And-
Well, you want to leave December 7th on?
We'll-
That's only a week away, that won't give
I
him
won't
time
have
to
time.
I
file.
was going to say, if counsel would stipulate to it.
To file a motion to rearrange the dates and for more time, I suppose. We got, when's the court date or trial? Do an order-setting trial, too.
July.
Oh, we got lots of time to hear a temporary motion. All right, the only thing I'm doing today, by stipulation, Dad doesn't object, is to lift your restrictions, Mom, and you get Friday 6:30 to Sunday 6:30 unless you and Sean work it out or between your attorneys. Otherwise, Mom will be forced to file a motion, and then we'll be back in court before July.
Just do whatever he wants.
Hang on. Since we're reverting back to the temporary order,
Yeah.
we say that she will return the subject minor to my client by...
Receiving parent
1 o'clock?
picks up.
Okay, you'll pick up by...
Receiving parent picks up.
About what time is good today to pick up, since it falls into his time?
I
We'll
believe
pick
the
up
child
noon?
is at daycare right now. They could be picked up.
You can pick up from
He'll
daycare.
pick up from daycare.
Friday 6:30, Sunday
Up at my
6:30. Are we
house.
clear? Unless they stipulate or go through their lawyers.
Thank you, Aaron.
Thank you.
You'll pick up from daycare.
The order from today.
I'll do the order.
Mr. Grigsby's going to do it. Ms. Stout's going to sign off.
Yes.
All right.